Okay, great. Okay, then again, a very warm welcome to everyone. And thank you for joining us for our opening lecture for the focal topic year on justice and sustainability, which will be held by Professor Luis Kotzé today. He will talk about the Neubauer et al. Case, and his the title of his talk is Neubauer et al. Versus Germany, Planetary Climate Litigation for the Anthropocene. And my name is Henrike Knappe. I'm the scientific coordinator of the focal topic year of justice and sustainability, and maybe just a few words about the focal topic year before we start. So this is our first IASS focal topic year on justice and sustainability, and we picked justice as a topic because we think it's of overarching relevance for many fields in sustainability research. And we observe that justice is coming up in many different settings of transformations towards sustainability. It comes up in very local settings where we observe kind of the consequences of transformation, being it the mitigation or the reinforcement of inequalities, for example, but also on more global issues and questions of global justice or even planetary justice, as Luis will talk about today. So that's why we think this is worth dedicating a whole focal topic year on. And so we will do our best at the IASS to really push forward relevant research into this direction and kind of highlight justice research, because we think it's really a topic that is becoming ever more relevant in sustainability science and also sustainability politics. Part of this focal topic year is this public lecture series that we are starting today, and it will take place every last Thursday in a month. And I can already announce the lecture for February now, so that you can already mark it in your calendars. It will take place on February 24th. And the lecturer will be Navdeep Bora, who's a research scholar at the Indian Institute of Science Education and Research at the Department of Humanities and Social Sciences in Punjab, India. And he will talk about the struggles for agrarian and environmental justice in Northwest India. So, but now we are very happy that Luis accepted the invitation to hold the opening talk of the public lecture series. And Luis joined us at the IASS this year as a Klaus Töpfer Fellow. He's a research professor of law at the Faculty of Law at Northwest University in South Africa, where he teaches international and African regional environmental law. He's also a senior fellow of Earth System Law at the University of Lincoln, and he has a quite broad research focus with three more interesting or the most interesting things, or he's most interested about are three topics that are first human rights, social ecological justice, and environmental constitutionalism, law and the Anthropocene and Earth System Law. And I think all those three topics will also kind of nicely come together in the talk today. He will give us some insights into a most recent publication he just brought out that he wrote on this German case of climate litigation that sparked really a lot of interest in Germany, but internationally as well. Luis is today joined by Jannis Krusman, a German law student who has filed a constitutional claim against the state of North Rhine-Westphalia. And there he and his fellow plaintiffs are calling on the state legislature to set a pathway to reduce greenhouse gas emissions in line with the remaining carbon budget. And Jannis will add to Luis' talk some insights into the practicalities of this climate litigation process, and also speak a little bit about the role climate litigation has for the younger generation of German climate activists. Before we start, and before I hand over to Luis, maybe some words on the proceedings. So we will start with the lecture of Luis, of course, and then with the comment by Jannis. And then we also have, of course, we'll give you the opportunity to ask questions and give comments to the speakers. And we want to kind of, as we are many people here today, we would like to invite you to ask the questions in the chat. And then we kind of either summarize them for you or pick out some people that can then ask the questions directly to the speakers. So it would be good if you can write your name in the chat when you're asking a question, or if you don't want to speak out yourself and rather preferred that your question is read by us, then also indicate this, please, in your question. Okay, then many thanks for participating, and many thanks to Luis and Yannis, of course, and then hand over to Luis, and looking forward to your talk.
Thank you very much, Henrika, and thank you everyone for this wonderful opportunity, certainly, to have a discussion about the Neubauer case today with you, and also the broader issue of climate justice and vulnerability. I'm really particularly grateful to Henrika for making all of this happen, and for the very kind invitation, together also with sincere thanks to the IASS. I see that Achim is also here, for all the wonderful support that you give to the fellows, and making these opportunities available and to make it all happen. I'm certainly also extremely delighted that Janus Kruisman is able to join us. We met coincidentally last year at a virtual event at Cambridge University, also that focused on climate litigation. And Janus will obviously also share his own thoughts on this. And I think we are particularly happy to have quite literally the future generation with us, and to hear from them how they experience climate injustices and how they go about actually getting their hands dirty in litigating these cases, in mobilizing support, and building on the positive momentum that is being created all across the world. So very, very much looking forward, and I suspect that his presentation will be the most interesting part of our entire discussion today. But perhaps then, just to set the scene in my own presentation, I will share the slides now. There we go. So I hope you can all see it. Good. I just want to note that I'm not a German law specialist. I am a South African lawyer with an interest in law in the Anthropocene and the planetary dimensions of law. So I can't really say anything useful or meaningful about the detailed nuts and bolts of German law and the German legal system, certainly also not the extent to which the court engaged with it. But what I hope to do is to offer a broad brush reading of the case through a planetary lens, which is an approach that I'm much more familiar with. And I obviously very warmly welcome also any and all engagements, and certainly also contributions from German law and governance experts during our discussion today. Now, the recent decision of the German Constitutional Court is one in a wave of so-called groundbreaking climate cases that are sweeping the world. And it has already attracted considerable attention. In this case, the complainants alleged, among other allegations, that the German government had failed to introduce a legal framework that is sufficient to swiftly reduce greenhouse gases and to limit the increase in global temperatures to well below 2 degrees Celsius and preferably to 1.5 degrees compared to pre-industrial levels, as is, of course, stipulated in the Paris Agreement. Now, the constitutional dimension of the judgment lies in the complainant's contention that certain provisions of the Federal Climate Protection Act are incompatible with some of their fundamental rights guaranteed in the German Basic Law or the Constitution, and that these provisions are therefore unconstitutional. And they specifically refer to obligations arising from the rights to life, physical integrity, personal freedoms, the right to property, and the right to a future consistent with human dignity, and its associated right to an ecological minimum standard of living. Now, in its judgment delivered on the 29th of April, 2021, the court unanimously declared that the Climate Protection Act is partly unconstitutional because it does not sufficiently protect people against future infringements and limitations of freedom rights in the wake of gradually intensifying climate change. Now, the court ordered, basically, the legislature to correct and to significantly tighten up the existing climate law provisions, to increase the ambition of these provisions, and to strengthen future mitigation pathways, notably by introducing specific provisions on how to reduce targets for CO2 emissions well beyond 2030. Now, the decision has mostly been lauded by commentators for its certainly novel approach to constitutional rights-based climate protection and its ambition at a time when the legal community and climate activists seem to be exploring, as we will also hear from Yannis, all possible legal and other means to address climate change more effectively, especially, I think, and as a response to the path-dependent and business-as-usual global efforts to tackle climate change, as we've also now seen again in Glasgow at COP26. I would suggest that a particularly novel and underexplored aspect of this judgment lies in its tentative embrace of a planetary perspective in the context of the Anthropocene trope. And by this I mean the extent to which the court has managed to adjudicate the matter not purely from a traditional and localized domestic context, as one would expect. This was a German domestic case after all, but how the court, either wittingly or unwittingly, has innovatively managed to embrace a more holistic planetary view of climate science, climate change impacts, planetary justice, and so forth. So my basic proposal is that Neubauer offers an example of how courts could and should start following a planetary perspective that is grounded in the Anthropocene context when adjudicating matters related to global disruptors such as climate change. And such a planetary perspective, I think, is what the Anthropocene trope ultimately demands, especially to the extent that this trope redirects our attention away from an outdated environmental management or environmental protection paradigm towards an Earth system-centered way of pursuing planetary stewardship. And I will today try and explore how the court has started laying the foundations of such an endeavor through its tentative engagement with fundamental existential questions of survival in the wake of the looming climate crisis, by tracing out some emerging themes and possibilities related to what one might term planetary climate litigation. So I will first discuss what the Anthropocene's planetary context broadly entails and why it has become necessary for us to start thinking in planetary terms. And I will then identify and elaborate the planetary aspects of Neubauer. Now, while there may be many others, I only focus on the court's reliance on, first, authoritative global climate science, second, its engagement with the issue of climate targets, tipping points, and constitutional obligations, third, the court's engagement with the issue of planetary climate justice, and finally, its elaboration of climate stewardship obligations. Now, my point of departure is that a planetary perspective has now become the contemporary regulatory context within which to consider and to govern interrelated Earth system transformations. I think we can agree that we live in an era that is characterized by acute socio-ecological decay that we observe on a daily basis. These ecological disruptions are all deeply intertwined. They impact an increasingly vulnerable living order, which is itself interconnected and interdependent. And they contribute to exacerbate a profoundly uneven world order that is characterized by continuing forms of eco-violence, economic predation, and the unparalleled imposition of precarity on humans and non-humans alike. And it is within this context of entangled planetary socio-ecological disruptions that scientists suggest humans are causing irreversible Earth system transformations. And these transformations are observable in terms of an integrated Earth system tipping points that are triggered by human activities. And once a tipping point is triggered, one can almost not go back to the state before it was not triggered. And the argument with tipping points is that human impacts are becoming so profound that we are pushing Earth system limits and thresholds to the point that we might tip over in a radically new state of being. And closely related to the idea of tipping points is the notion of planetary boundaries, which is another approach to visualizing an integrated Earth system, and more specifically also the limits of the system. So the planetary boundaries framework suggests it's possible to identify and quantify a set of 9 planetary boundaries, some of which have already been crossed, the climate boundary being one of them. And if they are crossed, the chance of maintaining the relatively stable Holocene condition that we still seem to be in, at least officially, significantly diminishes as we step closer to tipping points in the Earth system. Now, tipping points and planetary boundaries collectively serve as indicators that we are entering a new post-Holocene geological period in Earth's history called the Anthropocene. So it still needs to be officially declared the current geological epoch, but in the Anthropocene, human activity is now considered to be the major dominant cause of Earth system transformation. And the Anthropocene has become the standard narrative to appreciate the extent of human mastery and dominance over a very vulnerable, increasingly vulnerable living order, while at once providing the context for us to try and reimagine our interventions, be they law, culture, religion, broader governance interventions to respond to Earth system transformations. Now, the rise of the Anthropocene narrative and associated terms such as tipping points and planetary boundaries, I think has provoked a major shift in how we perceive and understand human impacts on the planet. And this shift has scaled up and redirected our attention away from a localized environmental context to a planetary context, as it were. So the progression from environmental to planetary thinking heralds nothing less than a long overdue paradigm shift. And it invites us to consider that Earth system transformations, while obviously ecological, are also caused by human-driven predatory paradigms and practices that impact the living order, such as slavery, appropriation, colonialism, extractivism, neoliberal developmentalism, and corporate ravaging in pursuit of profit for a privileged few. And I think it's also a lot of these issues that Enrique's focus group look at or will look at in the course of the work that we will be doing over the next months. Now, while the ecological aspects and implications of Earth system transformations are articulated by Earth system science-based frameworks, such as the planetary boundaries, the social aspects and regulatory consequences of Earth system change are revealed through emerging social science-based notions, and I only focus here on 2: Earth system governance and Earth system law. And both of these seek to translate, as it were, insights from Earth system science within the social science domain. Earth system governance is concerned with governing complex Earth system challenges at the planetary scale, while we have recently proposed the idea of Earth system law as a new juridical epistemic framework that can guide us to new interrogations on the difficulties posed to law in responding to a complexly intertwined and ever-transforming Earth system. And one can already observe the emergence of other ideas that seek to translate a planetary perspective into the social science domain on the back of these 2 epistemic frameworks. One example is planetary justice, which seeks to resituate justice and equity within a planetary context. The idea of planetary justice is, at least conceptually, broader than the more established notion of environmental justice, which, as Frank Bierman and colleagues point out, brings problematic connotations of a nature-human or person-environment dichotomy that does not capture the integrated character of social ecological transformations at a global scale. Another example of law's recognition of the social aspects, certainly of Earth system transformations, is Earth system vulnerability, where the concept of vulnerability, as it has been used in the human rights law context, has been expanded to apply to the entire Earth system, including Earth system processes, present and future human and non-human beings. And Earth system vulnerability, I think, propagates the insight that we, the entire Earth system, including its living order, are all vulnerable in the Anthropocene, notably by showing us that the Anthropocene's powerful Promethean human is also a vulnerable subject. Now, while this ongoing paradigm shift towards a planetary perspective will likely take time to embed itself in society, science, and our social regulatory institutions, the implications of such a shift for governance more generally, and certainly for law specifically, including law's agents and actors such as courts and the legislature, are as wide-ranging as they are potentially profound, especially in the context of climate change. Law and lawyers and other actors will have to start reimagining climate law alongside an Earth system perspective and the emerging frameworks that we have just briefly spoke about. More importantly, I think for present purposes, a planetary reimagination of law, whether it is done alongside these frameworks or not, will have to involve courts as creative judicial actors that have the power, the constitutional power, to innovatively steer the development of law into one direction or another. So let's look now at how the Constitutional Court has already started contributing to the reimagination of law alongside a planetary perspective in the Neubauer decision. Let's start with authoritative global climate science. So while other courts have also relied on climate science, and I'm sure Yanis will also tell us that in their own complaint, they might also be stressing this, to guide and bolster arguments, to justify decisions and arguments. The Karlsruhe Court's engagement with climate science was exceptionally extensive and innovative, I think. And such a thorough engagement is illustrative of a deeper appreciation of the value of authoritative climate science, the global context within which climate science is produced as part of Earth system science, and the relevance and value of climate science for mediating a domestic climate law dispute. In a rather lengthy analysis spanning several pages, the court fully immersed itself in what it called the factual background of anthropogenic climate change, its consequences and the associated risks. It does so by relying on assessments of the Intergovernmental Panel on Climate Change, which is a committee that collects and scientifically evaluates peer-reviewed findings of Earth system science-based climate studies from all around the world. Although not entirely neutral, unpolitical, or even uncontroversial, certainly for that matter, the IPCC's reports are generally accepted to reflect scientific consensus on climate science, the most up-to-date science. So the scientific consensus serves to guide states to create and set climate goals and to change their laws to achieve the outcomes of these goals. So obviously nothing prevents domestic or any other court to also rely on the reports and the science produced by the IPCC, which is exactly what the Constitutional Court did in this case. It drew on the IPCC's, what the court calls virtual unanimous scientific opinion, which was sufficient to convince it that, and I quote, the rapid acceleration of global warming that is currently observable in comparison with historical levels is essentially due to the change in the material balance of the atmosphere caused by anthropogenic emissions, unquote. And why is this important for the planetary context that we've just referred to? I think that the court's reliance on the IPCC's work signals its endorsement of a body of climate science that has a very distinct global character and that has been collated by a respected international institution, legitimately constituted by states around the world, and in which numerous scientists spanning the globe are involved with. And while the court also extensively, and correctly so, referenced domestic German studies, it was very much prepared to use the IPCC's work for the purpose of serving as the larger scientific context for its reasoning and as the context within which to understand domestic climate change impacts. In doing so, the court managed to open up a dialogue of sorts between global and domestic climate science, where the one informs the other, and where both shape the broader context within which the court has to make a legal determination. So the Earth system science perspective, therefore, also had a role to play in the court's assessment of a domestic climate law dispute. It shaped, at least to some extent, the legal context within which the court considered the constitutionality of the Climate Protection Act. And I would suggest that this is a tangible example of how judicial processes could enable the possibility of law being shaped, if not entirely reimagined, by a planetary-focused scientific perspective that lies at the heart of paradigms such as Earth system governance and Earth system law. The second point about tipping points, climate targets, and constitutional obligations. As was the case with its full embrace of authoritative global climate science, the court did not shy away from extensively engaging with the notion of tipping points that we mentioned a bit earlier. This is perhaps, I think, the court's most explicit attempt to try and understand climate change within a planetary context as an interconnected, complex, and multi-scalar Earth system phenomenon. And displaying a remarkable appreciation of Earth system dynamics in the context of tipping points, the court says, and I quote, "Tipping elements are components of the Earth system that have special significance for the global climate and which, when placed under increasing stress, as is the case, undergo abrupt and often irreversible change. It cannot be ruled out," the court says, "that a cascading series of such interactions could transform the Earth system," end quote. Its detailed reflection on interrelated tipping points leads the court to analyze, in an equally meticulous manner, the range and extent of climate change impacts in Germany specifically. It does so by reflecting again and again on the interconnected nature of the climate system as part of the larger Earth system, and how global climate change impacts also Germany. And in this respect, the court skillfully manages to avoid what one could call the bordered geographical, jurisdictional, and interpretative trap occasioned by inward-looking parochialism. So considering the very real possibility that climate tipping points might be triggered soon, as the court believes it would, the only rational solution for the climate emergency is, as the court says, to reduce CO2 emissions. Any such reductions can only occur when human behavior changes. And one of the most effective ways to change human behavior is through the regulatory institution of law, as we know. So most climate laws, including the German Federal Climate Act, follow the so-called target approach that seeks to limit climate change to an upper boundary of temperature increase. The target approach involves a logic whereby only a certain amount of greenhouse gases may be released up until a specific temperature limit is reached, in this case 2 degrees Celsius, 1.5 degrees Celsius. So the specification of these fixed temperature targets is guided by, among other things, Earth system science frameworks, also the Planetary Boundaries framework. And this framework has specifically been used by the German Advisory Council on the Environment, the Sachverständigenrat für Umweltfragen, the recommendations of which the court significantly relies on to guide its decision. So that the court was very much aware that the shape, content, and objectives of climate law and the extent of the legal obligations deriving from these laws will be determined and continuously shaped by the latest scientific research on climate change, it's clear from its view, and I quote, that Article 20A of the Grundgesetz places the legislator under a permanent obligation to adapt environmental law to the latest scientific developments and findings, end quote. This is very clear. And I think that this would suggest that this is one of the clearest articulations yet by any court of the mutually supportive and beneficial relationship between global climate science and international and domestic climate and constitutional law, and of the links between what the science says and the type of legal obligations that should ideally arise from these laws if they were to perfectly correspond with what the science says. In short, climate science must shape the law, and the law must be responsive to the state-of-the-art climate science, while meaningfully translating the planetary boundaries determined by the science into legal boundaries. So the court's exploration of tipping points and the target limits approach also has constitutional significance, as it helped to guide the court's interpretation of Article 20A of the Basic Law. The target approach allowed the court to derive maximum permissible emissions for Germany from the remaining global emissions budget, which was a central consideration in its assessment of the extent of climate burdens that will be imposed on future generations. As we shall see later on, the court essentially argued that an increased use of total greenhouse gas emissions by 2030 will disproportionately result in greater restrictions of future freedoms. Our third aspect is planetary climate justice. I think the court's engagement with aspects of the evolving paradigm of planetary justice lies at several levels. First, the court's cosmopolitan approach, for a lack of a better expression, in relying on climate science-based international climate law is one consideration, because this sends a very strong signal of its endorsement of the principle of international legal openness, or what Helmut Aust calls Völkerrechtsfreundlichkeit, as a method to interpret the provisions of the basic law that relate to climate obligations. The court's international legal openness points to its willingness to engage in processes associated with the transnationalization of environmental constitutional law, which is especially appropriate, I think, when adjudicating a legal issue such as climate change that is very much global or transnational. Secondly, and perhaps more subtly, I agree with Matthias Goldmann that when he says that the Constitutional Court's use of the IPCC reports resuscitates the functionalist hope in international institutions as havens of rational discourse, a rare quality in times of societal polarization, spreading autocracy, mistrust in public institutions, and even state-sponsored misinformation, as we saw under the Trump administration. The mere fact that the court relied on authoritative global climate science, I think, hints at its implicit rejection of false scientific balance and systematically constructed climate denialism and ignorance that have become, problematically so, deeply embedded in some sectors of society, as we also see with the current wave of anti-vaccination campaigns sweeping the globe. And these are all exemplifiers of the human capacity for bending rationality in order to accommodate hierarchies of power. And they are all fueled by the rise of these post-truth politics and extremist populism, radical anti-rationalism, and a sweeping rejection of rational science and the rule of law. The court instead fully endorsed the rational science approach, despite, or perhaps we will never know, because of intensifying skepticism of the IPCC and its work, which is being propagated by disinformation campaigns and conspiracy theories, and certainly supported by so-called merchants of doubt, such as special interest group associated with fossil fuel lobbyists and so forth. So if the judicial endorsement of authoritative planetary focused climate science also implies a rejection, even implicitly, of those predatory paradigms and practices that contribute to and intensify climate injustices at the planetary scale, as I believe they do, then the Constitutional Court has sent a very strong signal in support of crafting a scientifically informed legal response that is responsive to Earth system vulnerability, and particularly to human rights abuses and injustices associated with global climate change. And finally, the most obvious aspect, certainly of the court's engagement with planetary justice, is its clear findings on intergenerational justice and equity. To be clear, the court did not expand Article 20A of the Basic Law to include any form of fundamental rights for future generations, either human or non-human. It instead found that certain provisions of the Federal Climate Protection Act are unconstitutional to the extent that they create disproportionate risks that freedom protected by fundamental rights will be impaired in the future. And again, the idea of the carbon budget allowed the court to justify its determination of the Federal Climate Protection Act's unconstitutionality in terms of intergenerational equity. Finally, I would suggest that the Constitutional Court's approach in Neubauer shows what could be possible if courts were to embrace the task of becoming planetary climate stewards. And perhaps even more importantly, when they remind other organs of states, in this case, the legislature, that also they must become planetary stewards in the face of the Anthropocene's climate predicament. The court's implicit embrace of a planetary stewardship role is again evidenced by its willingness to draw on the rich body of Earth system climate science and its reliance on international law. This shows its appreciation of the importance of opening up to the planetary perspective when crafting the general interpretative context within which the law must be evaluated. Another more explicit consideration is the very clear way in which the court has managed to articulate and stress the importance of the need to govern climate change globally and for states to cooperate at the international level in this regard. The court is clear that the pathway towards climate neutrality can only be successful if it also involves international cooperation that is embedded in an international law and interstate context. At the same time, the lack of other states to act is not an excuse for Germany's reluctance to tackle climate change within and outside German borders. On the contrary, the court notes in paragraph 202, the particular reliance on the international community gives rise to a constitutional necessity even to actually implement one's own climate action measures at the national level in international agreement where possible. And this amounts to nothing less, I think, than the articulation by the court of a state philosophy of international involvement. As Helmut Aust says, eine Staatsphilosophie des international Eingebundenen, that must prevail among states that assume collective responsibility to address climate change, not only in their own territories, but also globally. In conclusion, I think there is a need to change human behavior, to protect planetary integrity, to avoid that climate tipping points are reached, and to remain within a safe planetary operating space. Law will and must continue to play an important role in changing human behavior, because this is what law does best. And where states' climate laws are insufficient to address climate change, both within that country and as part of the larger international community, we need astute judicial institutions to correct legislative anomalies within the permissible confines of the Rechtsstaat. The German court made an important contribution to this endeavor in Neubauer, I think. Its decision is historic for many reasons, and some of these will certainly be explored in future and have already been explored. And I've only focused on the extent to which the court embraced in a highly innovative way a planetary perspective that I believe has shaped the larger legal context within which it evaluated the constitutionality of Germany's climate law. One might, but should not, logically assume that a court will embrace such a perspective when critically engaging with a very complex global phenomenon such as climate change. After all, ideas such as planetary boundaries and tipping points have only emerged relatively recently, and it will presumably still take some time before they become fully embedded within the more formal legal processes. The emergence of these notions, however, does reflect the dawn of a new planetary consciousness, at least, that humanity and its regulatory institutions, its legal actors, including the courts, will have to embrace to be able to more effectively respond to Earth system transformations. And the Constitutional Court makes a singularly important pioneering contribution in this respect by showing what is possible when a court manages to revert to a planetary perspective. We now have an example of how the judiciary can play a role in addressing climate law conflicts when and where they arise. Karlsruhe, in short, has not only, I think, strengthened German climate law, it has also set the stage for planetary climate litigation. And I very much look forward now to Yanis's presentation. I've already created a sort of a teaser and a little appetite awakener with the last slide, and very much looking forward to what you're going to have to say about the nuts and the bolts and the bigger motivation behind your own effort. Thank you very much.
Well, thank you very much, Louis. I hope I can hold your pace, and thanks for the great teaser. Let me just share my screen. Yes, I assume you're now seeing my screen. Wonderful. Yes, well, as Louis mentioned, I'm going to talk about our constitutional complaint against the State Climate Protection Act of North Rhine-Westphalia. And well, later I'm going to give some personal remarks on my opinion and what I think is the young climate movement's opinion of climate litigation and its role in German climate policies. Yeah, maybe first of all, I need to say that what we're trying to do is to copy the Neubauer decision on state level. So we do not intend to invent something new. We're just trying to copy what has been decided on federal level, on state level, but also in front of the Federal Constitutional Court, of course. Yeah, I'm first going to present something about the North Rhine-Westphalian Climate Protection Act and how it was amended in the past year and what impact the Neubauer decision had. And then I'll just briefly summarize what we're currently doing there. Yes, and then finally my personal remarks. And yeah, as Louis said, we believe that the Climate Protection Act of North Rhine-Westphalia too is not compatible with our right to secure future. And yes, that's our claim. First, I need to say that the amendment process of the current Climate Protection Act started already in 2020 and was taking, and continued in the last year. And what was obviously the aim of the government of North Rhine-Westphalia was to water down the current Climate Protection Act. I'll call it KSG for Klimaschutzgesetz. Yeah. And this amendment protest started before the Neubauer decision and ended afterwards. And we're going to see what has happened in the meantime. First, I'll point out some examples of how the Climate Protection Act was weakened during the amendment process. First example is that paragraph 4 of the law was weakened because in the old version it said that the climate targets are directly binding for the state government, and in the new version it says that the state government has something like a role model function, whatever this is supposed to mean. Yeah, but I think we can assume that this is nothing good for state climate action in North Rhine-Westphalia. Another quick example can be that in the past, the state government had to provide a plan that the administration of the state, which will include universities, for example, is completely climate neutral by 2030. And this paragraph was just cancelled in the new amendment. Moreover, paragraph 6 is a bit more complicated. We now have what they call a climate protection audit instead of a climate protection plan, which is, I would say, it's the same. But the difference is that we don't have any more intermediate goals for the emission reduction that have to be continued in the plan. There are no sectoral strategies anymore, and there are no goals for the expansion of renewable energies. And maybe most importantly, there is no deadline for the audit. So the former climate protection plan had to be continued every 5 years, and this audit doesn't have a deadline. So we can wait for it maybe, I don't know, 5 years or 10 years, we'll see. So far, there's no audit. And paragraph 8 is also a bit confusing, but the sense is that the government tried to weaken the monitoring process. So it makes it harder for the public to understand what they are doing with state climate action in North Rhine-Westphalia. And my final example of how this law has been watered down in the past year is that now we have again, instead of an advisory council, an advisory committee, which again is just a different wording, but it means that we don't have any more evaluation of the monitoring processes because there are no processes of monitoring anymore. And the government doesn't have to comment on the reports of this new advisory council, because in the past, this advisory council could report on climate action in the state, and the government had to comment on these reports within 3 months. And this was just crossed out altogether, as you can see. Yeah, there's nothing new. It's just crossed out. Okay, this was what happened in 2021 before the Neubauer decision, and now we'll see what impact the decision actually had on the North Rhine-Westphalian amendment process. The first and foremost thing the government did was that they tightened the emission reduction goals, and they did so by copying the new goals of the new federal Climate Protection Act, which means that now the official goals are a reduction by 65% by 2030, using 1990 as a base year, and to reach net zero emissions by 2045, which is exactly what's written in the Federal Climate Protection Act today. But the question is, are there any accompanying measures? I mean, they tightened the goals, but that would mean that they had to give some accompanying measures too, right? They did not, of course. And this is a label fraud, of course it is, but we're quite optimistic that the Federal Constitutional Court will recognize this label fraud. Therefore, we believe that our chances in front of the court are quite good, I would say. I'll talk about this later a bit. Yes, where are we right now? Right now, our complaint is pending. We filed it in July 2021, as we could have seen on Louis' screenshot of the complaint, and we hope that the court will find the decision within this year. I mean, the court itself said that the topic is very urgent and we cannot waste time on climate action. Therefore, we believe that they should have incentives to find a quick decision. And moreover, the rapporteur within the court is going to is going to leave the court in March 2023. Therefore, we believe it would make sense that the same person reports on basically the same complaint. And this is why we believe that we'll have a decision within this year. And as I already mentioned, our chances are quite good because what the government did is they tightened the targets, but they didn't give any measures to it. I mean, this is very obvious that this cannot happen, and it is still violating our basic rights to freedom and security. And yeah, I just want to clarify that we, for complaintiffs, we have not written this complaint ourselves, of course. We are being supported by the German environmental NGO Deutsche Umwelthilfe, who has also been one of the complainants in the Federal Constitutional Court's decision in Neubauer. And they are also financing and organizing other climate cases right now. For example, they have, I think in 10 German states, they have constitutional complaints against their climate protection acts or against the fact that they don't have a climate protection act, because there are still some states in 2021 that don't have a climate protection act yet. But Deutsche Umwelthilfe is also financing lawsuits against Volkswagen and BMW, for example. And I'm not sure if anybody has noticed, but yesterday there was a press conference saying that they filed another constitutional complaint against the same Federal Climate Protection Act because it still does not meet the expectations that a younger generation has. Yes, that's right. But honestly, I'm not too much into this topic, so maybe we can discuss this on another day. Yeah, I will conclude with some personal remarks of what I think about these the role that climate litigation plays for myself and for the climate movement in Germany, especially the students' movement. Here you can see a picture from 2019. I started organizing protests in 2019, well, quite much 3 years ago now. And at first we thought that we'll have protests for some weeks or maybe some months, and then the governments will agree with basically every scientist in the world that it would make very much sense to have more climate action. And then we realized after some weeks that it's not going to be that easy. And we started talking to local, national, regional politicians. And they said, yes, yes, we appreciate that you're demonstrating and we'll do something about it. And they didn't. And finally, on the very day that this picture was taken, and that you can see here, the German government or parliament passed another Climate Protection Act amendment that was very disappointing to the climate movement. And then the COVID crisis started to begin. And of course, we weren't able to have demonstrations like this anymore. But we thought, okay, maybe if the public learns, and the politicians learned something from the COVID crisis, they can also apply this to the climate crisis. And right now, I would say this has not worked out yet. We'll see how it turns out. And yeah. And then in April 2021, the Neubauer decision was published. And this was, first of all, a really big surprise, not only to me, but I think to most of the young students in the climate movement. And it was also a reason for us to gain hope again. Because at first, I think this decision would have not been possible without 2.5 years of climate protests, not only in Germany, but also worldwide. And what Louis mentioned earlier, without climate science and the IPCC, because the court very much relies on the IPCC findings, as Louis has explained. Yes. And now what happened that the four of us, you can see Mia, Tobias, me, and Lea in the picture, that the four of us decided to support the Deutsche Umwelthilfe or be supported by Deutsche Umwelthilfe, either way, to file a constitutional complaint against the State Climate Protection Act. First of all, North Rhine-Westphalia accounts for 28% of the German carbon emissions. that is more than Netherlands, for example. And it has also a big history in coal. I'm not sure if anybody knows, but between Cologne and Aachen, there are some open pit coal mines. So coal is a big thing in North Rhine-Westphalia. And we are certain that the North Rhine-Westphalian Climate Protection Act in its current state is a threat to our future. And it is also proof that the government does not take our future seriously. And therefore, we see that our basic rights are being violated by this law. Yes, if you scan the QR code, you'll reach the website of Deutsche Umwelthilfe. You can find more information there on the lawsuits, not only our constitutional complaint, but also other climate litigation cases. And last but not least, there are going to be state elections held in North Rhine-Westphalia in 4 months, I guess. So we're going to see how this turns out. Either way, we won't stop suing until our future is safe. Thank you very much for your attention. And I'm looking forward to this discussion now.
Thank you, Janis. Thank you, Luis, as well, for those really inspiring talks. And yeah, I would like to immediately open the floor to everyone. If there are any questions to Janis and Luis, go ahead and either write in the chat or raise your hand. So there's one question by Simon van Eckert. Maybe you can just ask yourself, because it's the first and only question at the moment. So just go ahead, Simon. Can you unmute yourself?
I can read the question from Simon. I fully agree that the authoritative global climate science should play a role in climate litigation. Now, in this case, we have the example of the Constitutional Court, which job it is to be critical of national legislation. Do you think it should play the same role in civil courts? Or should judges be more careful when integrating scientific insights in this context? I don't really think, honestly, that it would make a difference whichever court it is. It can be, I'm not all that familiar with the German court system, but just speaking from the South African example, which I presume would be similar to the German one, is that courts would always need authority to base their decisions and argumentations on. It is often simply a matter of which type of authority that they use. And I think that's also the argument that we try to make in this, or that I try to make in this paper, is the fact that the Constitutional Court used this globally generated authoritative science that's been peer reviewed and so forth and endorsed, and that makes a big difference. And I think it's very plausible that it can be used in any other court. I can even imagine that it might be used in a criminal court. If there's any German lawyers here who might know better, you're welcome to say it. But certainly, in speaking for my own country, that would be very possible to use it in any judicial forum as a means of supporting and underlying the argument and the case that you want to argue.
I think we now made it possible to unmute yourself again, so you can. But then I go ahead with Sunaida Musa. You raised your hand. Please go ahead and ask.
Thank you very much, and good evening to everybody from Johannesburg, South Africa. My question is directed to Professor Louis. And I just want to know, Professor, when you refer to the impact of the Neubauer case with regards to planetary climate justice, I have 2 questions stemming from there. How are these terms synonymous to concepts such as transnational and global, and how are they different? Because this is something I'm doing research on, and I'm finding it very hard to actually define these concepts. And then my second question is, what type of a distinction would the Neubauer case make with regard to also planetary climate justice in a distinction between the global north and the global south? Thank you very much.
Thank you so much. It's lovely to hear the South African accent. It was unexpected and very, very nice to hear that. I feel at home. So perhaps just to start with the second question first, it's something that I didn't discuss because of time constraints, but the court also actually referred to north-south dimensions of justice to the extent that some of the complainants in the case also were from Bangladesh, for example. Now, what the Constitutional Court did here is they allowed these non-German citizens, as it were, standing, so a very wide liberal locus standi, but they didn't find in favor of their claims, arguing based on the principle of state sovereignty. It's not a German constitutional court cannot order the German government to take action in another country. That is impossible in terms of international law. And the court obviously recognized the limitations imposed on it by the principle of state sovereignty. So the decision very much also focused on dimensions of north-south injustice, which is part, I think, of the planetary justice paradigm as well. I just didn't mention it because of time constraints. And I think that the court made the right decision there, because it isn't up to German domestic court to tell the government to intervene in the national policies and circumstances of any other country. As regards your question about planetary justice, this is a fairly recent term, and it has been it is being developed by people such as Frank Biermann, Prakash Kashwan, and several other members of the Earth System Governance Network. And there's even a special issue on that that's open access, and that I would encourage you to read. The journal is Earth System Governance. And you can just look for the special issue on planetary justice. That's all open access. And the main argument seems to be that we need to move away from these paradigms of environmental justice, which is extremely limiting, certainly conceptually, in that it only focuses on very narrowly defined environmental pollution problems, for example, and the immediate effects that it has for communities living in the immediate vicinity of such environmental degradation. A movement to a planetary perspective broadens our vision that we can also include present and future generations, that we can also include non-humans, which is increasingly becoming an important topic within the discourse, of course, as we also see with the rights of nature discussions that we are having. And that one can also make a clearer distinction that injustice in the Anthropocene, or vulnerability in the Anthropocene for that matter, isn't something that's universal. Some people are more vulnerable than others. And one can see this much more clearly through a planetary perspective. And I think that is also the motivation behind the development of conceptually broader and more encompassing terms such as planetary justice. But do have a look at the Earth System Governance publication, special issue on planetary justice. I think there's about 8 publications there that would certainly help, I think, guide you in your thinking about these issues. Thank you very much for these questions.
Thank you. Okay, the next would be Mark Lawrence, Director of IASS. Mark.
Yes, thank you, Henrika. Thank you so much, Louis and Janis, for these wonderful insights, for the hard work that you've both been doing at not only digging deeper into this academically, but really bringing this to the courts and also, Janis, to the streets. We haven't, Louis, I look forward to seeing you next week. I can't welcome you with the South African accent, but I can welcome you to Germany, and it'll be nice to see you again when we meet next week. And Janis, we haven't gotten to meet yet. I'm one of the directors at the IASS, and I've given a number of talks and both scientific presentations and also inspirational talks at the demonstrations, like at the large demonstration in Potsdam last year. And I'm very, very pleased at the work that you all are doing and that we connect in with scientists. My background is not in law, but rather in atmospheric chemistry, meteorology, pollution, and climate science. So my question might be a little bit naive, but I hope you'll bear with it. To both of you, Louis as an established law researcher and Yannis as a budding law researcher, what kind of, I don't know the term for it, positive Pandora's boxes does this open? So Pandora's boxes usually has a negative connotation, but I'm thinking about positive Pandora's boxes that this opens in terms of other behaviors of our society that have comparable impacts on future generations. And of course, you can think of on the health side in terms of tobacco, alcohol, or even refined sugar added into food, which has been long since swept under the carpet, but the connections of that to type 2 diabetes have impacts that are comparable to the global pandemic that we're facing right now in some countries, particularly in the US. Or if we go to the environmental side, things like microplastics, where we don't yet have the science on the table, but we will, or multi-resistant bacteria that come from the use of antibiotics globally in the meat industry that may also have environmental consequences for the possibility to feed our future generations that are comparable to the kinds of impacts that we see through climate change because of their impacts on biodiversity, their impacts on insect loss, biomass loss, and so on. So this court decision around the one topic of climate change is extremely important, but I'm wondering what implications does it have for other topics? What can we look forward to in the future from this as a precedent, if anything, or is that just a naive question from a physicist?
You are welcome to go, Yannis.
Okay, thanks. I can have a try. First of all, I think it's not that easy to take this as a precedent because this is connected to Article 20A of the Basic Law, which has to do with environment, of course. And therefore, I'm not sure if you can connect this, for example, also with pension funds, which are right now maybe difficult to explain to younger generation why the pensions are still that high, and we all have to pay this back in the future. But I can imagine that this would also apply to, for example, antibiotics, what you mentioned. There's something in chat. Yeah, exactly. I'm not sure if this can apply to the financial system because this has nothing to do with Article 20A of the Basic Law in Germany. Therefore, I think this is very hard. But for example, antibiotics or biodiversity, I think this would work because what we have in biodiversity law is, I mean, basically every species that is extincting is also some kind of a tipping point for itself. And with this understanding of tipping points, I believe the Constitutional Court could also have opened the door towards stopping the extinction of more species. But maybe, Louis, I assume you can add better.
No. I don't think I can add anything better. But just perhaps to follow up on your excellent insight here is that I think what the decision does signal is that courts such as the Constitutional Court are going out on a limb here, and they are not afraid anymore to be innovative and to push the boundaries as far as one can within the separation of powers to make the type of decisions that we need to see in order to achieve, for example, climate neutrality, or as you say, to prevent the negative impacts of antibiotics or the global financial crisis. So I think it sends a more broader general signal that judicial institutions are becoming a bit more gutsy and innovative also while doing that in holding other branches and certainly also the civil society actors such as companies and corporations to account for their actions. And that's also why it's important to have people such as Yanis and groups of civil society actors to actually bring these cases to court. And apart from that, I might also just add that the decision was a German decision based on Article 20A of the German basic law. But what we also see increasingly is this type of a transnational judicial dialogue that is emerging, where courts across the world are borrowing from one another. Courts are talking to one another. Even in forums such as this, where judges would have a judicial forum and they would compare. And I mean, in many constitutions, I suspect the German constitutions, like the constitution like the South African one, has very specific provisions which allow courts to consider foreign law when interpreting constitutional provisions. That's certainly the case in South Africa. So that would mean that when a similar type of case, even in a different context, might arise in South Africa, that the South African Constitutional Court would be very likely able to borrow the approach and the perspectives that the German Constitutional Court had in Neubauer. I hope, Mark, that this more or less, from a legal perspective, answers your question.
Yes, thank you. I'll take that also as a stay tuned to see how this develops out. But I didn't realize that about the connection between the national and the various national courts. That's quite an interesting aspect of that. And especially, of course, the separation between the environmental aspects, which can be captured, and the health aspects, which cannot be captured under this particular one as a precedent. Thank you.
Thank you.
I would have another question to Yanis, actually. And you closed your talk with the sentence, "We will not stop suing until our future is safe," something like that. And I wanted to follow up on this and ask you what you think, or what you would estimate how relevant and how effective climate litigation processes are for you. You also mentioned the Fridays for Future protests and so on. I think those climate litigation processes becoming also a political tool for activists and becoming successful in a way is kind of new. And would you say more optimistically, okay, this is something where we can complement all other kinds of political actions that we are doing, or would you say this is rather your only chance to kind of safeguard your future?
Thanks for the question. I would not say it's our only chance, but right now it seems like our best chance, because as I've explained earlier, we've been protesting for 3 years and more or less nothing has happened, at least not even close to what's necessary. And with just one bang, the Constitutional Court just drops a decision like this. And this is I think the biggest step that has happened in the past 3 years. And therefore I believe, and what I also know from my friends in the climate movement, that most of them start looking towards courts as the main driver of climate action now, because politicians have failed us. But well, we do also agree that we still need protests to keep the courts going. I mean, without the protests, the courts, I mean, they also need to have some public legitimation for their decisions. Otherwise, they would not be respected anymore.
There's another question from Wolfgang Stenze, I think, in the chat. Do you want to?
No, thanks. I mean, actually, what I had thought of already had been clarified by the chat comment from Achim Maas.
Okay, great.
Thanks, Achim. If I might very briefly just jump in there, I think what would be interesting in the future is to see whether any court would be willing where a constitution does not provide for a rights of nature provision. In other words, where a constitution or a law does not explicitly recognize the rights of non-human beings, whether a court would be willing to really be innovative and recognize the rights of both present and future non-human beings. That would be interesting. I mean, we already see this happening in Latin American countries, and Cecilia's work here at the IASS also focuses certainly on that. But in Western countries where the rights of nature paradigm has not been embedded mostly at all, it would be interesting to see whether a court would be willing to really go out on a limb, and perhaps also what one of Mark's Pandora's boxes, and see if it can articulate or formulate and justify also rights for non-human living beings.
Thank you. Then Carlotta Garofalo.
Thank you very much. Yeah, I think that the Neubauer decision is also very effective in showing a bit the limits of human rights in tackling climate change from this planetary perspective as well. So it seems the court is recognizing the tipping points, but from a human rights perspective, it's just, human rights are just not enough to compel the government, for example, to be bound to the 1.5 target rather than the 2 degrees target. So I was wondering, what are your thoughts on the court's interpretation of the human rights? If you think that was restrictive, that the courts could have done more? And also there is an obiter dictum where the court is saying more could have been done if the right to an healthy environment, more or less, would have been recognized. This was tried, but politically it's not the case. So do you think that there is that could open new chances if this right would be politically recognized, or at least legislative or the constitutional level, also given that at the moment the political situation in Germany seems to be favorable to that? And also Professor Kotzé mentioned the principle of international openness. There has been recently a recognition from the General Assembly of this universal right to an healthy environment. So do you think that if Neubauer would have happened after that, that might have also influenced the reasoning of the court? Thank you very much.
Thank you, Carlotta, for this question. I think it is a very relevant and important one. I'm very mindful of the limitations of human rights, and I have always been fairly critical of human rights as instruments to achieve environmental protection generally, for various reasons. The one is that human rights are very anthropocentric. They protect human interests. And human interests are very often, certainly in Western legal systems, formulated around neoliberal development impulses, which very much sustain themselves by exploiting the vulnerable living order, especially the poor, through slavery, colonialism, extractivism, and so forth. So there is a lot to be said for the drawbacks of human rights. Yet, having said that, human rights, I think, still has a lot of normative, but certainly also symbolic power in trying to mobilize social society movements and legal actions, as we've seen also in Neubauer, to achieve a desirable end or a desirable result. And while the German constitution does not explicitly recognize the right to a healthy environment, I don't think that any constitution specifically needs to recognize that to achieve what a right to a healthy environment would ultimately aim to achieve. We see it, for example, in the Indian constitution, which also doesn't have a right to a healthy environment, but the courts have used the right to life, for example, the right to human dignity, the right to equality, as the means to get to the result that would have been given by a right to a healthy environment anyway. And I think this is also what happened here. The range of the rights on which the Bundesverfassungsgericht relied in its decision, in the end, I think achieved the same as it would have had there been a right to a healthy environment. perhaps even more. And the court, as you I think correctly say, got to that point because it was open to an enlightened view of what authoritative global climate science is, what the reality tells us about this is the problem that we need to fix because this is what the science says, this is the gaps in the law, and this is how the law must change so that we can achieve the end result of what is predicted by the science. I hope that answers at least part of your question. I don't know whether Yanis also might have a view on the use of constitutional rights.
Yes, I think from a political perspective, the court must have tried already very much to be hesitant and not to put too much pressure on the government and the parliament, because otherwise we would step into a problem with separation of powers. And there's already this argument that the court is maybe a bit too over-aggressive and does too much, and it should rather focus on just checking the law and not inventing new figures to make sure that climate action is actually being done. And therefore, I don't believe that via human rights or anything else, the court would have dared to come to another conclusion than what it did now.
Thank you.
Are there any more questions? Yes, Andreas Schwan, please go ahead.
You can hear me, I hope. Great. Yeah, thank you for this lecture. And it's a really interesting topic. I'm not really into that yet, so I'm quite an amateur. So if there are any mistakes in my argumentation, please excuse them. So I was wondering, because Louis, you were talking about how human rights approach now can be used or was used to fight for climate action, so to speak. Could you think of any case where the exact opposite might happen, sort of that human rights would be used for an immediate situation that contradicts environmental protection and thus creates a counter case at a court? And if yes, how to react to that?
Andreas, this is a very difficult question. I mean, I suspect it depends on what type of rights are being argued in front of the court. I think the general premise is that the court will only adjudicate and decide on the law that is being put in front of it. In other words, if it is in the environmental context, it can and will only decide on the specific rights that are pled and that are being raised in front of it. So I cannot imagine that, I cannot think from the top of my head of any situation where there might be two opposing rights, certainly in the climate change context. I mean, what one could argue, and just taking the example from the South African legal system, we have a right to a healthy environment, but we also have a right to economy and free trade. So in certain circumstances, let's say, for example, Shell, which wants to drill for offshore gas on the South African coastline, could argue, well, we've got the human right to economic development, whereas an environmental interest group would argue, no, well, you do, but we've got the right to a healthy environment, which is directly opposing. And that then certainly would be up to the court to balance the two rights and see which one prevails. But apart from that, I am not sure that I can think of any other specific example, unless I understood your argument incorrectly.
No, I think you fairly understood it well. It was more like this idea of if you have a conflict of interest, and now what this case of Neubauer sort of had a precedence character on court, that if there is any risk of the exact opposite happening again in another context. But I think you quite explained it well.
No, sure. I think I understand you now. And yes, that possibility is always there, because it will also depend on each specific case and which type of rights are argued and the type of conflict, of course, that is involved. So the type of conflict that is involved will determine the type of rights that will be invoked. And this is something that Jan is certainly, and his team has also been exploring with their own legal counsel, in what type of rights to use to argue the case. Perhaps, Janis, you can, I don't know if you have any specific contribution to this from your own experience.
Yeah, I wanted to share some thoughts on this, because I believe in the short term, it's for sure possible that climate action infringes any other human rights. But I believe the Constitutional Court in Germany has made very clear with its term of intertemporal freedom that it prefers to look in the long run. And therefore, if you weigh the short term versus the long term, that you should rather look on the long term. And even if we had a situation that in the short term there are some violations of human rights, then it would be the task of the politics to make sure that this does not happen. And if it's still going to happen, then politics failed, but not the court, I would say.
That was the better answer.
Okay, there's another comment. Mark, do you want to say something, or?
I'll just say what Andreas just said is sort of the other side of the Pandora's box. So there's the flip side. There's the positive side that I was looking for to see, could we use this for other cases? And Janis made very clear that environmental cases, such as though the use of antibiotics and their impact on the environment, or perhaps microplastics and other things that would have an impact on future generations, and the viability of future generations could indeed be positive cases that could be influenced by this precedent. But I think that then the negative side, what we typically think of a Pandora's box, once you open the lid, then you have all the demons out, is what Andreas just pointed out, that people could actually take a look at this kind of legislation and try to flip it around and use it for their express individual purposes rather than for common good purposes. And that's really interesting. Once the courts allow themselves to take a step this far, then who says that extremely conservative or even populist courts, like we nearly have at the Supreme Court of the US, wouldn't take that as a precedent for also stepping much further than the typical bounds that have been accepted. So that's where it becomes, to me, especially as a non-expert observer, very, very interesting to watch this.
And I think that is a very good point. And it is unfortunately a possibility, certainly as you point out, Mark, in certain jurisdictions. Although I think there's also something to be said for observing a generally positive trend in terms of the judiciary globally, taking very bold and positive action towards positive change, not only in the climate and environmental domain, but in numerous other domains as well. And I think that is also precipitated by this current anti-rationalist disregard of the rule of law type of environment that we find ourselves in, where the courts kind of feel more emboldened to step forward and to act and to assert themselves more deliberately as actors of positive change. And of course, courts can only do so much. We must also not be unrealistic. We are fortunate in Germany and even in South Africa that there's still something such as the rule of law. And if the court decision is this, and it must be implemented, this is also what the German government did. But in many countries, this is obviously also not the case. And the composition also often of the bench is very much political. So I'm not a political scientist, but I can imagine that there will also be a discussion, and that the discussion must be had about the political influences on the bench and the composition of the bench, and what that might imply for the eventual outcome of decisions. Certainly in the context of the US, I think in climate change and with the traditionally more conservative Supreme Court there, very powerful fossil fuel lobby groups and so forth might have, perhaps, this is guessing, a more persuasive effort on the outcomes of a case than what would be here the case in Germany. But this is just a guess, but it is a possibility, I'm sure.
Okay, thanks a lot. And I think we can close now the discussion if anyone else wants to ask a question. And yeah, again, thanks again, Luis Kotzé and Janis Chrisman, for your really interesting and inspiring talks, and also everyone else for the lively discussion. And I'm very happy to follow up on the public lecture series next month. And I'm wishing you all a nice evening, and thanks a lot.
Thank you.
Bye-bye.
Bye.
Yeah, thanks for the invitation.
Thanks, Henrika. Great job organizing that.